This morning we heard some interesting comments about how one goes about reaching certain key decision points in terms of the discretion to move forward, how you strategize a prosecution. And today and this afternoon, we're going to follow on with that in terms of another important decision point, and that is who actually is going to do this prosecution. And of course that's important in a federal system because obviously we have two possibilities. But even apart from the federalism aspects, there are many times interdepartmental considerations to consider as well. We're going to explore both of those aspects in this session. The first speaker is Susan McCrory, who is certainly well known in Alberta and may well be well known to others of you. She has a long history as an environmental prosecutor in Alberta, and her name appears frequently, whether she likes it or not, I guess, in the newspaper. The second paper will be given by Martin Olszynski of the Department of Justice here in Ottawa, again attached to Fisheries and Oceans, and that addressed the second problem, that is the intra-governmental aspects of deciding who should prosecute. So without further ado, I'll turn you over to Susan McCrory.
Thank you, and good afternoon. You got to remember, I'm trial counsel. I don't care about policy. It doesn't really affect me in my day-to-day life. I've been a trial counsel for 31 years, and the last 20 exclusively doing environmental prosecutions. So that's all I do. So believe me, this is not a policy paper. This is not a legal discussion. This is a very practical one. But before I start, I do want to say that I feel that I've been incredibly lucky. I started 20 years ago, and it was coincidental with the creation of the first, I think, serious attempts in Alberta at effective environmental prosecutions. There was an unpleasant experience many years ago. There was a big pollution event. The then Minister of Environment went on the TV to say the folks responsible for this will be held accountable, only to find out that in fact the company had been permitted to do the release that it did. That resulted in a white paper, and as a result of the white paper, there were significant changes in Alberta. First of all, with the proclamation of the Alberta Environmental Protection and Enhancement Act, also with the creation of a position for a dedicated prosecutor. So I feel very fortunate that I've been able to be in that role for the last 20 years. I also think I've had an incredible luxury of doing the work that I have. Since the beginning, the environmental prosecutions have been within the Specialized Prosecution Unit. And that is a marvelous advantage to you Crown that are like me, started out just doing regular Crown work. Not enough time, not enough resources. Within the Special Prosecutions Branch, the philosophy was that the file should be trial ready on the day that you recommend charges going ahead. So I've been very privileged to have that time and that luxury. And if any folks listening in are policy folks, decision makers, I can tell you my recommendation, this is the only way to go. But that's not what I'm here to talk about. I'm to talk about federal, provincial cooperation. And it makes me laugh to think that there's only 5 of us in the province who specialize in this. And my friend Alex from the Feds is here, and I'm here. We represent 2/5 of the entire organization that does environmental prosecutions in Alberta. Such a small group of people means that we know each other and we like each other. And that's a good thing, because the offenders that we deal with are some of the biggest corporations on the planet. We don't deal with million-dollar corporations, we deal with billion-dollar corporations. These folks have the resources to defend honorably, but hard. And you know, I'm trying to think back on one of the early prosecutions of Shell Canada. And I'll never forget, I wander in with my one little briefcase, and I look across the table. There are 5 lawyers on the other side. Peter Martin, one of the, I'd say the 3rd best cross-examiner on the planet. Earl the Pearl Wilson, you know, the dean of the law school at the time. Jim Ogle, a brilliant guy, and there was this 1/5 guy whose only job was to carry their bags. I remember thinking, oh, I want one of those too. You know, it's a funny story, but that's the reality of the folks that we are coming up against. So that if we are going to be an effective deterrent, but what I mean by this is I don't look at my job as winning or losing. I'm a crown. There's an old saying, the crown never wins, the crown never loses. But I do think our job as environmental prosecutors is to raise the priority of environmental protection in the hearts and the minds of these big corporations. And the only way to do that is to be not so much win, but to put together a credible, serious, impressive, honorable attempt at a prosecution. If you do all of those things, you're probably also going to be successful, but that is not the end of the game. So how do we do that in a jurisdiction where there's only a few of us? We're humble civil servants. We do not have all the resources on the planet. So again, this concept of federal and provincial cooperation is not a matter that I think you can put down in paper or in policies or, as they tried to do many, many years ago, a matter of agreement. It really does have to be a working cooperation between the two sides of the fence. Now, how do you accomplish that? There have been some bad old days in federal-provincial cooperation in Alberta. And I saw some of those bad old days as having the potential to undermine the credibility and the effectiveness of the prosecution. There are a number of things that we cannot have. And this is my word of warning. We cannot have turf wars. That is evil, and it undermines the credibility of the prosecution. That a decision whether to accept a plea or not cannot be based on, well, I want some of mine and you get some of yours. It can't be like that. It's got to be what is the best offense, what is the appropriate charge for the circumstances. So how do you avoid that human tendency? I want what's mine and he wants what he's getting. And let's not be shy about this. The pressures from the investigative branch. Each investigative branch has invested a fair amount of time and energy in their investigation, and there is a natural tendency to say, but I want something for my work. I want something for my labors. That cannot be. That is not the business of prosecution. That is not the business of investigation. The business of prosecution and investigation is the file. The file must have the priority. The file and the health of the file must be the deciding factor in how the file is managed. How do you eliminate that natural tendency for turf wardom. And I think there's some very practical things that you can do. First of all, we make an investment in each other's offices. Alex may have a file that he doesn't have time to do. We all have limited resources. There's paternity leave, there's maternity leave, there's illness, there's people's other ambitions. My buddy, Peter Roginski, who shares the province with me, is on secondment right now for the ERCB. So in this year, I'm a little short. And so I turn to my federal friends for assistance. So rather than saying, well, okay, let's look at the law, who is the Crown for this? I think better still, what are the resources that are available right now for this particular file? And to make the decision of labor based on that. And that's exactly what we've been able to do in Alberta. How do you do that, though? And again, I'm about 5 weeks away from retirement, so I can be a little bit more controversial than I used to be. And again, if there's policy folks out there, how do you make that happen? And my advice to the head office folks is stay the hell out of our business. I work with wonderful, wonderful bosses. I have super bosses who are some of the best litigators. I'm proud to know them. But the environmental work is different. It's not the same old, same old. So that a boss who has spent his or her entire life on the criminal side of the fence may not be the best person to involve in some of the decisions on as you were talking this morning, some of these strategic decisions. Because the approaches that one takes with a bank robber do not work with a corporate entity who makes billions of dollars, who is in other times a fine, upstanding corporate citizen. And I'm, again, very fortunate that my bosses say, this is not my area of specialization. I can talk to them, but I will not be my decisions will not be overridden. The other very practical thing, and this is just from being an old country prosecutor, we used to have a saying that only the person who read the file has a right to offer an opinion on it. And so again, the people that actually do the work, who actually are intimately familiar with the file. Again, there's nothing wrong with a boss saying, have you thought of this? But at the end of the day, it's got to be the decision made by the Crown who's standing there. Everyone in this room who's ever stood up in court knows there's a very different feeling 2 minutes before you stand up than when you're 6 months down the road, you're in head office and it's not your file. So again, if we are, and I think we are outgunned when it comes to environmental prosecutions. Head office, put some faith, give some credit to the poor buggers who are actually doing the work. The other thing, practical recommendation, is to make these decisions, these hard decisions on how to divvy up the universe in advance. Don't wait for the bad thing to happen. And it was, I think, a real life lesson for us on the Syncrude trial, is the investigators from both the federal and the provincial side and the prosecutors sat down before the charges were laid and said, guys, we're in this together. Regardless of which charges go forward, if the federal charges go forward, so be it. We're here in an assisting role. If the provincial charges only go ahead, vice versa. And we, years before the trial, made a determination that we were going to help each other. And we divided up the work on the file based on the expertise. Alex is a brilliant, brilliant researcher. Guess who gets the constitutional? We have a brilliant Kent Brown, brilliant lawyer, great litigator. He did the expert witnesses. And I did the rest, because I'm a bit of a country crown. So this division of labor predates any of the unpleasantness. Before the conflict arises, we know who's responsible for what. On Syncrude, there was, of course, an issue as to whether Kineapple would apply. And you can imagine, again, from the outside, so you get a conviction on both counts. Which one goes down and which one survives? The decision that if Kineapple had been successful on Syncrude, we made long time in advance to say that the federal charges were the ones that were more serious. It wasn't rocket science, they were indictable offenses. End of story. But you make those decisions a long time before. You announce those decisions to your political masters a long time before, so that you're not faced with standing there in court and the pressure to, as you say, hang on to your charges. You know, I would really hope that we can also invest in each other's investigative services. Because as much as we are outgunned when we stand in the courtroom, when you know you've got the 5 lawyers on the other side and you know there's a host of them back, the investigators are also in a precarious situation. You know, think of it. You may have let's say you're an engineer. You are now walking onto the property of $1 billion corporation. The fellow that you're about to interview is the vice president in charge of operations. These people have incredible power, incredible resources. How do you feel as the investigator asking the hard questions? So what we've tried to do in Alberta is to realize that no one investigating agency has the resources to do it all. And so we've, for the last, I think it's going on 7 years now, we hold an annual conference in which we have investigators from all agencies involved. And we try to do issues that are of interest to them. Because, as you know, in my little paper, I say the time to meet your co-investigator is not standing there on the bank of the river when the bad thing has happened. So this investment in the investigators will, I can guarantee you, pay off. I think sometimes I'm an old crown, so there used to be this philosophy that the Crown was to be totally separate and apart from the investigative service, that you received the file and you made a determination solely based on that, almost like an English barrister system. It's too complicated to do it that way. The issues are too hard. The investigators are too challenged by what they're facing. You have to have a situation where the Crown is going to be able to assist in the early stages of the investigation. That does not mean that the Crown run the file, as much fun as that might be. It's still the investigator's job, but we have to, I think, be available. We have to assist them. We have to offer them support during that difficult stage. Now, in Alberta, we have a very, very strict dividing line. The file, until it is formally referred to me, doesn't belong to me. Every piece of advice that I offer to investigators before the file is finally referred to me or formally referred to me is advice only. The investigators can pay attention to me or they cannot pay attention to me. But at the point where the file is actually formally transferred, then the decisions on the file are in fact my responsibility. But we still need that investment in the investigation. And again, if any of you folks in policy are out there, is to recognize the value of giving time to your Crown to give that kind of advice, to offer that kind of assistance, to give your Crown some time to make themselves available, to do the teaching, to put on courses on search warrants, to do, what's that old commercial, the pay me now or pay me later. But that is a labor-intensive exercise for which your Crown needs some time. So, I think the hardest or the thing that drives the wedge between the federal prosecution service and the province is we work under two different systems. The special prosecution system, as I've explained, the investigator provides us with the file asking us for our recommendation. No charges are laid unless the Crown says so. But that is after the file has been extensively reviewed. And again, I'm privileged to have the time to do that. And the kind of review, as I indicated under the special prosecution system, is a complete review, so it's almost trial ready. The federal side is more the tradition, from what I understand, is the more traditional way of a file coming to Crown, where the police prepare the court brief or the file summary, and oftentimes the decision to make whether you go ahead or not is not based on a review of the honest-to-God file, but based on a summary of the evidence prepared by the investigator. Again, I would suggest that that's more appropriate for the drug work and, dare I even say, for murders. I mean, you used to do murders all the time. And the sad thing is one murder is very much like another. The problem is with these environmental files, when you are going to be challenged, and you're going to be challenged at the ultimate level by some of the best lawyers out there, you better know what your problems are before charges are laid. You better know where your holes are before charges are laid. You better have got your expert witnesses in line before the charges are laid. Or you have no hope of meeting that kind of challenge from defendants who are that sophisticated and that well-funded. My suggestion, again, I get to be controversial. Make up your mind which system you're going to follow. If there's a joint investigation, and if there's going to be a joint exercise, if you're going to have two Crowns sitting at the table, make up your mind which rules of engagement you're going to follow before. This failure to do this was, in fact, came very close to undermining one of our major prosecutions in Alberta. It was a situation where the Crown on the provincial side was ready to go. The federal Crown were not. And you can imagine the accused is not looking forward to the prospect of having two prosecutions at the same time, one by the feds, one by us. And this is a hard lesson learned. We were able to get through that, and in fact, eventually both sets of charges did go ahead at the same time, and at the 11th hour there was a guilty plea. But I think that's putting too much pressure on your folks not to have those kinds of arrangements done in advance. Sentencing. Another thing is to have that discussion a long, long time before the trial actually goes ahead, so that there's not unhappiness, there's not a sense of you got a better deal than I did, or you got more for your buck than I got for my buck. Make those decisions in advance. So, now, I've been going on about how important it is to have this cooperation and all the terrible things that can prevent that cooperation from happening. But let me close with saying there are huge advantages to having both federal and provincial charges going ahead and having the cooperation between the investigators and the Crown. We have different elements of the offense. I love the Fisheries Act. Love, love, love it. Oh, it's just too wonderful. You don't have to prove adverse impact. Do you know how hard it is to prove adverse impact? So there will be many situations where the best charge, the most provable charge, is in fact the Fisheries Act. And I learned a lesson a long, long, long time ago on another case that I won't mention the name of. I could have and I should have laid Fisheries Act, and I didn't. And it was sort of early in the day, and I had this sort of sense, well, that was their stuff and this is my stuff. Absolutely wrong. So if you have this good working relationship, does it matter whether it's a federal charge or a provincial charge? If the effect is the same, that it does increase the level of awareness in the industry says, well, I don't know who's coming after me, but if I'm bad, someone's coming after me, and it's going to be effective. So there's a huge advantage to making use of each other's legislation. Federal folks have wonderful, wonderful provisions as far as getting your certificates for some of your testing in. Lovely. Take advantage of it. The other thing that I would exploit is this tension between the province and the feds is very helpful to encouraging hard work by the investigators. It's, again, sort of a natural thing, I think, to say, well, I'm going to work on my side of the fence and they'll work on the other. But the fact that charges are being pursued by the federal agency is an inspiration to some of the folks on the Alberta side, and vice versa. And the other huge advantage, and this is a very personal one, is when you have a federal agency that's doing a joint prosecution with you. If you are getting political pressure, if you are getting pressure from your bosses, you can say, well, the feds are doing this. Well, nobody wants to look like they're not holding up their end of the stick. So you use that conflict in the ultimate to produce a better file. As I say, I've been doing this for a very long time. I've had way, way, way more fun than I ought to. I have enjoyed tremendously. The Syncrude prosecution was one of the funnest things I ever did. And it's because I had my federal friends along for the ride. We had a wonderful time. And so as I'm moving into the sunset, if I can say the lessons learned for 20 years, again, get along with your federal friends or get along with your provincial friends because you need each other. So, thank you.
We're really just softies, as Susan has indicated. Okay, some questions. Here's one right now. Do you ever prosecute concurrent with provincial administrative proceedings on the same incident? And are there any challenges there?
Yeah, you can't. I can't prosecute, but there can be concurrent civil and criminal proceedings. And that happens a lot because you've got the problem of the cleanup. I may be prosecuting for the bad thing that happened. What are you going to do about the cleanup? And the challenge is to separate the two functions. On the cleanup side, on the administrative side, on the civil side, of course, there's an obligation of the accused to cooperate, to provide information. And what you can't have is that self-incriminatory self-incriminatory evidence, self-compelled evidence, finding its happy way over to the criminal side. So what happens is the minute that we understand that there are going to be two proceedings, we assign different investigators to keep them separate and apart.
Okay. I had a question, just because it's so fascinating, the whole Syncrude decision. I wonder if you could elaborate a little bit on, just as a practical matter, how that was built as a case between the federal and provincial crowns.
Practical thing, when the bad thing happened, who came running? Both provincial and federal investigators, because it's Fort McMurray. There aren't enough of them to go around. So you have two investigative agencies, actually three, because you had Fish and Wildlife turn up at the same time. So when it starts as a joint investigation on the investigative side, the natural is that it be a joint prosecution as well. If it's a small file, not so much. If it's a small file, we do sit down and say, can you take this? Should I take this? But on a big one, it was a natural occurrence. So.
Okay. Maybe just as a footnote to that, you mentioned the cooperation between federal and provincial regulatory agencies, and I think this annual conference that you hold. Again, do you have any insights in terms of how investigative agencies build that sort of cooperation and don't step on one another's toes?
And you have to do that. We've had some, I remember the Wabamun situation. Wabamun, there was a traffic jam on the first day of the spill between all the investigative agencies who turned up. You can't have that. You have to have that thing organized in advance. And this is why in Alberta we have been pushing for the major case management system, so that when you have investigative agencies, they all understand they're all running by the same business rules. And that's one of the primary things we teach at this annual conference. You want to make those informal connections, but you also want to set up the business rules for the big file when it comes.
You mentioned one other thing I think that people will be interested in, and that is the luxury that you've had to review files. Now, sometimes these files are going to be enormous, I assume, and that does mean a luxury both in terms of just dollars, human resources. Have you got any sense of whether or not that is a realistic approach for other provinces, having talked to other, I'm sure, provincial crowns from time to time?
Well, if you don't do it that way, you're not going to be too successful. So I think you either make the investment and you do it in that fashion, and maybe you don't have as many files. But as you folks in the environmental prosecutions business know, it's not about prosecuting everyone who comes down the pike. It is effectively prosecuting the few, because in the environmental business, the companies get it. It's not like bank robbers. Bank robbers, you got to prosecute them all, because they'll all be doing it. You only need to prosecute one or two industry actors to get the attention of the other folks in industry. So either do it good or go home.
You also pointed out that the feds have a different way of proceeding. They don't read the files. They read a summary of the file prepared by the investigator. Does that create problems for you, someone who has read the file, in terms of meeting with federal counterparts in a timely way? I could see the problem for some disjunct there.
I think there is, but the nice thing is the folks that we have in Alberta on the federal side, I don't know how they do it. They do try to read the whole file. They might do it on their own time, but they try. I just wish the system would allow them to have the luxury of that time.
And a question from the floor. If the Crown assists in the early stages, and I think it means assists the counterpart, Crown, do all these communications have to be disclosed to the defense?
Well, this is kind of interesting because I don't think there's a right or wrong answer to it. I can tell you my position is that, in fact, Crown direction absolutely should be disclosed. There are other prosecutors who say, no, that's work product, and that should not be. So I don't know what the answer is. I only know what I do, and I disclose it.
Okay. If there are no further questions then, I think we can probably should move on to the counterpart. But first of all, I'd like to thank Susan very much for a really great presentation.
Thank you.
As I indicated, our next speaker is Martin Olszynski from the Department of Justice and attached to Fisheries and Oceans. And he's going to address another problem of, I imagine, turf, in a sense, and that is within government, and particularly within the federal government. I think most people here know that there are several major pieces of environmental legislation that the federal government is responsible for. And the question then becomes, how do you deal with those? And some of those aspects are going to be dealt with by Martin right now.
Okay, well, thank you very much. Very happy to be here. I'm going to start off with a disclaimer that my boss asked me to provide. These are my own views, obviously not those of the Department of Justice. Alex, you can borrow my slide retroactively. I also want to add another disclaimer. I'm not a prosecutor, let alone one with the kind of experience that Susan or Paul and my colleague Alex bring to the table. I have spent the last 5-6 years in a legal services unit at the Department of Fisheries and Oceans, and so I have certainly worked on some prosecutions in that context. I'm also relatively handy with a PowerPoint, so I hope to at least make up a little bit for that delta there. So today, I'm going to spend a couple minutes first talking about some of the major federal environmental laws, and I think that that's useful not just to inform the discussion that we have at the end, but also because, as has been pointed out, I think earlier today, environmental prosecutions are tried generally in generalist provincial courts, and so it's not a bad thing to maybe talk a little bit about some of those actual provisions. I'm then going to move on to the key players, and really, from my perspective, there's really three that we want to talk about. We want to talk about enforcement personnel and what they bring to the table and the role that they play. The Public Prosecution Service of Canada, obviously focusing on the federal side, and then the Departmental Legal Services and the role that we play in. And really it is actually very often it's a supporting role, a mediating role. And then finally, again, looking at some of the legislation that I'll just briefly talk to, we'll look at a couple situations where, and try to apply some of the principles of which charges to lay. So the Fisheries Act, like Susan, I also love the Fisheries Act. And there are really two key provisions that the courts are going to find themselves dealing with. And so Section 35 prohibits what we call a HAD, a harmful alteration, disruption, or destruction of fish habitat. And for us, usually in our shop, we generally associate the Section 35 prohibition with physical works and undertakings, construction activities. Alex talked about riparian areas, so a couple examples. There might be work going on adjacent to a water stream, a riparian area, but that work might have an impact. If you find yourself with an excavator in the middle of a water body, that's probably a HAD. And you might think that doesn't happen very often, but you would be surprised. And then there's the sort of really one of the more important pollution prevention provisions, which is Section 36 of the Fisheries Act. And this is the one that Susan, I think, was speaking about, where you don't have to prove adverse effects. And so we know from the Kingston case and also McMillan Bloedel out of BC, the focus of this prohibition is on the substance being deposited, not on the receiving environment. So as long as you can show that X substance is bad for fish in a general sense, we don't have to prove that it was bad for fish in the specific sense. So that's very useful, and that's an important thing to keep in mind. So those deposits are prohibited unless they are authorized by regulations. And so some common ones. I mentioned in the paper the metal mining effluent regulations. Two other ones, the pulp and paper effluent regulations, always obviously very important. And our most recent regulation, really to join our family, the wastewater system effluent regulations. And so I should say, backing up, that so that's one difference. So Section 35, you actually do have to prove site-specific harm. You have to show that the work or undertaking in that instance did cause a harmful alteration, destruction, or disruption or destruction of fish habitat, whereas here we don't. And so the other thing to remember also in our discussion is that Section 35 is administered by DFO, the Department of Fisheries and Oceans, where I am, whereas EC, by Prime Ministerial Fiat back in 1978, Section 36 is actually administered by Environment Canada. And so we have two different enforcement agencies dealing with these things, and they work together, and we'll see that they, in fact, do try to bring some kind of coordination and consistency to their compliance and enforcement activities, but it's not always possible. The other, I talk about SEPA a little bit in my paper, and also the Migratory Birds Convention Act. I'll talk about SEPA a little bit because I think it's, as things get going a little bit on the toxic substances regime, we're going to see that a little bit more and more. This is a huge piece of legislation, SEPA, 340 some sections, 12 parts. I think, again, the one that you're going to bump into more and more in the criminal context or regulatory context, Part 5, which regulates toxic substances. And so the idea here basically is Part 5 sets out a fairly detailed regime for the minister to assess substances, chemicals largely, but also products of biotechnology. And depending on the result of that assessment, he might pass all kinds of regulations which deal with all kinds of things from manufacture to import to release. And so we have several examples here. We're talking about PCBs, we're talking about benzene, ozone-depleting substances. Part 7 is also where we find Canada's disposal at sea regime. And so this is the scheme that was dealt with in the sort of constitutionally significant Crown-Zellerbach decision, now housed within Part 7, Division 3 of SEPA. And this one, essentially, this provision here prohibits disposal at sea and dealing with substances other than those that are derived from normal operations, unless in accordance with the Canadian permit. So this is, again, a fairly clean and elegant provision in that it doesn't depend on harm, showing any kind of harm. It's basically, what are you depositing? Are you authorized to deposit that? If you're not, you're cooked. And this photo here, this is a recent prosecution done in BC of the MT Champion. And so I refer to this in my paper as the Mexican fish oil scenario. We had a Dash 8 surveillance aircraft. Transport Canada also has a mandate with respect to marine pollution under the Canada Shipping Act. And they observed this hose coming off one of the manifolds of this ship depositing a substance, and there was a wake of about 35 kilometers. And we'll talk a little bit about where that went, that investigation. And so it's interesting, Professor Collins mentioned earlier, these efforts to find out about enforcement activities and that these were maybe obscured in the 90s. Right now, actually, it's actually very trendy to put information about enforcement activities online. So, for instance, I've got two. The one is the Environmental Damages Fund website. That's a federal website administered by Environment Canada. And if you go there, you get little clips about recent prosecutions, recent fines. It's a good resource. It kind of gives you a sense of the kinds of things, kinds of cases that are being brought forward. It could be better, I might say, in my personal opinion, that it would be good to be able to get your hands easily on judgments as things stand right now. If you're interested in a case that's referred to, for instance, on the EDF website, you got to call the courthouse basically, or try to find it on CanLII. Ministry of Natural Resources also is starting to publish information about their recent enforcement activities. So I think that for practitioners, if you want to get a sense of the kind of things, even for judges, frankly, if you want to get a sense of the kind of things that are being dealt with. So, let's talk a bit about the players now. And so the first line really is enforcement personnel, and these are going to be variously designated. Under the Fisheries Act, we refer to fisheries officers or fishery guardians. We also have inspectors who are, have less powers than the former two, but also have some power. Game officers under the Migratory Birds Convention Act, conservation officers under various provincial legislation. And so these are generally guided by enforcement and compliance policies. I think Paul mentioned that they have one over there. We certainly have one at DFO. Environment Canada has them. And so I set out in my paper using the 2001, so it's a little bit older, but it still is the policy in place right now. So for compliance and enforcement of the Fisheries Act, Section 35 and 36, this is a document that was co-written by DFO and EC, and it's available on their website, on the EC website. And so it says, for instance, when dealing with different kinds of offenses, whether to proceed with an inspection or a warning or a direction, right up to a prosecution, you want to look at the nature of the alleged offense. You look at the effectiveness in achieving the desired result with the alleged violator. And so this is really about compliance. The fundamental goal here isn't to, take down as many companies as you can or whatever. It's to achieve compliance with the legislation. Consistency with enforcement, that's obviously also something that these agencies are thinking about. You want to make sure that there's even, especially for a federal agency, I don't know if it's as much of a problem for provincial agencies, but certainly federally, even within DFO, we talk about, the West Coast DFO and the Ottawa DFO and the East Coast DFO, and you want to make sure that there is some basic consistency there in the approach. I also want to spend a little bit of time talking about sort of a recent shift, I think, that we're seeing in compliance and enforcement, and I think that it's something that may have an impact on the kind of cases that judges are going to be seeing, Crown are going to be prosecuting. And it's this movement from what you would call pyramidic approaches, essentially a responsive escalation of responses to an alleged offense that really focuses on the offender really and their behavior. So you might start with discussion, persuasion, soft kind of techniques, moving up to inspections and ultimately prosecution. And certainly that's always going to be, I think, relevant, but we're starting to see a change and a movement towards what's called risk-based approaches to compliance and enforcement. And so I just provided on the left hand, this is actually taken from a slightly different context, but I wanted to illustrate a bit what I mean by risk-based approaches. So for instance, on the x-axis here, I can use this. Here we have, so for instance, this is a risk management framework or matrix for assessing impacts to fish habitat. So on the x-axis here, you might have sensitivity of the habitat, and on the y-axis, you have the scale of negative effect. And so, for instance, if agencies are looking to concentrate as much of their resources as possible to those risks that are most important, most significant to them achieving their objective, you might, for instance, you're looking at an area of habitat and you say, well, that's a low sensitivity habitat. It's not that, it's not necessarily, it's fairly resilient, you can say. And the impact is going to be low. So we're right here in this area, and so this is a low-risk activity. DFO doesn't have to worry about it as much, for instance. But if you move into even a high-sensitivity habitat, then even low-scale negative effects might be problematic. We might have a medium or even a high risk. And again, this is just for illustration purposes, but you can create these kinds of axes and these kinds of frameworks so that the agencies can target their inspection and enforcement to get the most bang for their buck. And that's not to say that low-risk activities are ignored. Of course, they're not. A good risk-based approach would include targeted, sort of focused inspection, but also, for instance, random inspections. And Paul mentioned that there still are random inspections in the low-risk area, just to remind the people in those areas that they are, there still is a prohibition here, but really focusing those efforts. And so, for instance, it's just a screenshot from the Ministry of Natural Resources. So they're talking about moving towards risk-based approaches to focus on those incidents that pose a risk to human health and safety, our natural resources, or our economy. And again, the details are for the risk people and for the policy wonks, I guess. But there are ways, there are matrices, there are ways that you go about this risk assessment to sort of really focus those issues. One example, and I mentioned this in the paper, so for instance, Environment Canada has moved towards, in the SEPA context, they're moving towards a risk-based approach. And so they look at their catalog of regulations, and they've determined, for instance, that there are four that are quite important, for whatever, based on the risk factors that they put into place and the things that they're looking at. Those regulations really need a lot of effort, a lot of enforcement hours. So you see that 50 to 60% of the available resources are going to those 4 regulations, as opposed to the referral ones, for instance, which might be mostly managed on a self-report basis or something like that. And so we see this gradual transition, and it's a work in progress for sure. No one's gotten it, I don't think, just quite right, but we certainly are moving in that direction, especially, I think everyone is aware, in these times, these financial times, every agency is looking to maximize their efficiency. So then the other two players, the PPSC, and I think this is really prosecutors generally, whether provincial or federal, and I'm not going to add to what Paul and Susan and Alex have already mentioned. I mean, the basic goal here, the basic preoccupation is sufficiency of evidence and the public interest. The one maybe comment to make is that it's really in that second category that departmental enforcement personnel play a role, and they might provide some insight and some perspective to the prosecutor. And while it's not theoretically binding, it certainly, I think, is a relevant consideration. And then DLS services, myself and other people that work in these departmental legal services, our job really is to provide support. Certainly, there are times, and there have been times where sometimes DFO counsel have acted as agents and prosecuted cases themselves, but for the most part, our job is to, at the first stage, assist enforcement personnel in understanding they might bring a situation to us. They might say, look, this is a scenario we're contemplating moving forward on this. What is your perspective? What are your views? And then on the tail end, once that's already happened, once the prosecutor's been engaged, we might work with them to sort of make sure that they understand the scheme as we understand it anyways, and to provide them whatever support they might need. So then I can, coming back to the scenarios that I set out in my paper. So the first one, going back to this Dash 8, this MT Champion, the ship that was observed off the coast of Vancouver Island. And we have this routine surveillance that's going on on Transport Canada actually has these planes, national aerial surveillance program under Transport Canada's sort of leadership. And it observes this oily slick. It's not quite sure. It does a couple runs back and forth. There's transcripts, audio transcripts. The next day, actually, they do call in various enforcement personnel, and actually they board the ship and they talk with the captain. The captain sort of indicates that he thought he was doing nothing wrong. But in any event, it's clear. What turns out is that the agency or the ship was depositing fish oil. So not petroleum, not hydrocarbons, but it had been carrying a shipment from Mexico, and for whatever reason it was dumping some ship oil. And so fish oil. So what we have here is we have a couple of potential offenses. We have disposal at sea, contravention of Section 125 of SEPA, but we also have a contravention of the Migratory Birds Act, or a potential contravention, right? And I said on my paper, one of the prohibitions under that act is depositing a substance that's deleterious to migratory birds in areas or waters frequented by those kinds of birds. There's also potential offense under the Canada Shipping Act. I'm not going to get into the details of that, but that's certainly what brought TC into the game. The second scenario, Mudfest, this is an off-road race. This is you got your SUV and you're running around in the backwoods somewhere. There was actually a recent prosecution in Alberta, I think, where a fellow decided to take a joyride with his truck through some streams, and he ended up getting hung up, and he was prosecuted. In any event, in this case, after the good times, our guys are washing down their trucks, and there's a ton of mud and silt coming off their trucks, and that is eventually making its way into the river. And in that instance, the river is a migratory route, a spawning habitat, and also fishing grounds. And I should say that, so both of these examples that I'm discussing are based on actual prosecutions. And so here again, we have two potential offenses. They're under the same act, but bear in mind that one is administered by DFO and the other one's administered by Environment Canada. So you have potentially two different agencies with different perspectives on this. And so the HAD, we can show that sediment, when it's introduced into a river, into a water body, it can have all kinds of impacts on habitat. It might cover up spawning grounds, or it might actually get in the gills of fish that are in the area, and that might prevent them from, basically just impedes their life processes. But it's also, it's a substance. It's something that's being deposited into the water, and so on its face it also appears to contravene Section 36, which is against depositing a deleterious substance. So in those kinds of instances, we have multiple departments engaged with potential interest in prosecution. And so I guess the first point to make, and I don't make it I'll make it right now, is that there isn't any, really it's an application of everything that you've all heard this morning and this afternoon, applied to the different potential scenarios. And so in this instance, in the first instance, let's talk about the Section 35 versus Section 36 issue. It's like Susan mentioned, Section 36.3 is kind of a slam dunk sometimes. You don't have to prove site-specific harm. And the fact is that site-specific harm can be difficult to prove. And we have a recent case out of the Northwest Territories where the court says, site-specific harm, environmental harm is difficult to prove. Ascertainable and quantifiable harm is very commonly difficult to prove. So where you have a provision, if you have an offense that doesn't require that site-specific harm, that's something that you're going to pay attention to. The situation is made that much easier if, as Alex mentioned, if the legislature or the government has itself, through regulations, prescribed a substance as deleterious, then all you need to do is prove that that substance was there. In the case of silt, in fact, some courts have taken judicial notice that silt is a deleterious substance. So when a prosecutor is faced with, trying to prove site-specific harm or argue that this is a deposit of a deleterious substance, which, by the way, this court found as a matter of judicial notice is a deleterious substance, well, I think it's fair to say that the prosecutor will be influenced by that. The other thing that's tied to that is that, different offenses require different kind of evidence, and that there's a cost issue there. Certain kinds of evidence are easier to prove. The evidence is easier to gather than others, and that sort of ties into the second factor that I'm sort of discussing in my presentation today. And I've talked with Paul about this a little bit because when he talked, the question came up to him about cost-benefit analysis, and I'm not contradicting him, I don't think, in any sense. I think it's fair to say that at least for low risk, less significant offenses, there is a certain amount of money that's involved in preparing submissions for court. And I got copies, for instance, of EC's submissions in this MT Champion instance, right? And so you have to prepare witnesses. Those witnesses have to show up at court. You have to prepare a synopsis. So there are documents that have to be prepared, and those are person hours, right? Those are people who are out of the office and whatnot. So if you have an agency that's already stretched and is looking to maximize its enforcement dollars, I don't think there's no harm in saying that they are going to be paying attention to these issues, especially when we're talking about those sort of less significant, lower risk activities. So I think that brings me really to the end of my presentation, and I'll take any questions and comments.
We wait for people to do questions. I just remind our web audience, again, who are in the vast majority, that on the bottom of your screen you should see a email address where you can send questions and we'll transmit them. I was intrigued by a number of things you said. One of the most basic, and it's sort of a collateral issue, I guess, it isn't restricted to environmental offenses, and that is the creation of the PPSC. In your view, has the creation of that as an independent entity apart from justice, has it affected at all how you as a departmental counsel proceed? Is there a difference between having essentially a non-departmental agency out there now making the decisions?
So so part of it is that I joined in 2007, so I didn't have too much experience with the prior organization. But from my sense of working on files with prosecutors, whether it's in BC or Alberta or in Ontario, I don't think actually at the working level, I don't think it really has a lot of impact. My understanding of it, and I did a little bit of looking into it for the purpose of this paper, and I think part of it was accountability at a high political level and a certain separation, whereas before the Federal Prosecution Service was a part of the Department of Justice, and there might be people here who could speak better to this than I, it is now an independent organization that does report still through the AGC. One of the changes that I'm aware of is that where the Minister of Justice, who is also the Attorney General, where he, for instance, seeks to instruct the PPSC in a certain way, he has to now publish those instructions in the Canada Gazette. So that's one of the changes that resulted. So but you know, on the ground, in terms of our relationship and our working with prosecutors, it's always been incredibly collegial and incredibly, productive. Yeah.
One of the things you mentioned in terms of the guidelines of the PPSC guidelines was the question of public interest and how you go about, because that's a factor in deciding whether or not to go forward. Is the question of the public interest one that's confined to departmental discussion? I presume if a minister is being lambasted in Parliament over a matter of, you know, that's achieved high public interest, that's bound to enter your considerations. I'm not too sure if the views of the environmental community, for example, get explicitly taken into account.
You know, so again, it's a bit out of my, certainly doesn't fit within my traditional, my responsibilities, but I think it's fair to say that both of those things do percolate their way into the agency's decision making. I mean, certainly when you have a high profile incident like the Syncrude prosecution and that occurrence, certainly when whatever investigative agency was going to be responding to that situation would have been very aware of, you know, comments that are made, for instance, in the media and stuff like that. But I do think, and at least from my personal experience, is that these agencies, whether it's DFO, Environment Canada, are acutely aware of their reputation amongst Canadians, and that includes with the public interest organizations and stuff like that. It is I think, you know, working within government, you essentially are the mediator of those interests. You know, you have those very public interest groups pushing for a very, pushing and for what they perceive to be the public interest, and then you also have these other interests that the government is very aware of, stakeholders, industry, economic interests, and stuff like that. And so, all of that stuff, I think, it's fair to say, does inform those perspectives.
And ultimately, though, it would be the PPSC that makes the decision, though.
Yes, at the end of the day, it's the prosecutor who has the ultimate decision making. Whether in those jurisdictions where there's pre-approval to give that approval, but in those instances when there isn't, the prosecutor always retains the discretion to stay a prosecution. And so, in practice, and I've spoke with some of my colleagues in the PPSC and in the lead up to this, and I think most of them said that the general practice is whether it's a pre-approval jurisdiction or not, there is always that consultation going on.
In terms of interdepartmental interests, where you have, and you've given some examples of acts that are governed by different departments who may have different interests. I don't know the degree to which this is a practical problem, but assuming there is some hypothetical difference of opinion amongst departments as to whether or not to go forward or under which act even. How do those questions get resolved? Are they resolved through Department of Justice Counsel? Is that a mediating role that you would take, or?
Yeah, and I think that actually that's good, because that reminds me of something that I think the one thing that sometimes when we get, and certainly myself, when I get talking about some of these things, it can seem all very academic or even mechanic, but at the end of the day, a lot of these decisions, this is all about like people. When it's people with their various dispositions and their various approaches and their relationships and the dynamics between them. And so, there's not a magic, there's certainly no magic bullet where departments disagree on an issue, and I imagine those do occur. And I think I've actually been, I can think of a few that are sort of on point. It really is just everyone sort of talking and trying to communicate and coming to a resolution, but I would say it's more consensus-based than anything else.
One of the things that struck me about some of the examples you gave, for example, would be that there would be an inclination if 36.3 is on the table, if that's a possibility, under the Fisheries Act, the deleterious substances, that regardless of whether or not other departments have also got interest, that just in terms of expediency, there'd be pressure if indeed there's pressure on human resources, there'd be pressure to go that route.
Yeah, but I would also caution. I don't think that it's certainly something that you have to take into account, and I think that a prosecutor would be live to. But I think there can be overriding issues, and if the particular department feels that, notwithstanding that sort of low-hanging fruit, they have a particular regulated community, and they have something that they need to, there's a reason for them to want to advance that prosecution. They believe it's in the public interest. Then they certainly will go ahead and do that. It's not a bar to that, so long as they can, present sufficient evidence to convince the prosecutor that laying that charge should be done in that instance as well.
So the inclination would be, or the possibility might be the department, even if it might seem of lesser importance, or at least the public prosecutions, it might be that they would want to get a precedent for the industry that they're regulating.
I think,
guess.
that's one example. Absolutely, they may be, and I think there's a lot of considerations that I think will play into it. It'll depend also on which agency was involved, and I think that's one actually. In fact, it points, where certainly there might be example where there's conflict between departments, but I think what the MT Champion example is really good about, and I think it echoes a little bit the federal provincial thing, is that these departments are actually all working together to share their intelligence and to share their investigative capacities. And so in the case of the MT Champion, actually, although that was a Transport Canada surveillance craft, the charges were actually laid by EC because it received that information through a sort of sharing arrangement with Transport Canada to get that information. So, so in a sense, there is a broad dissemination of those events, of that information, so that at least all the different players are aware of and can make a decision on their own whether or not they think it's worthwhile to pursue some kind of enforcement activity.
How much do you find that's a practical reality, the possibility of really serious disagreements amongst departments?
Because it's kind of like, I think most basically it's sort of to each his own. I mean, at the end of the day, if a particular department feels strongly that it has the evidence and it wants to proceed with enforcement, if that's the way it's played out in its assessment of the issue, it's not really for another department to tell it whether or not that's a good idea. Sometimes departments that have no interest or no specific, are out of the game, may sometimes look to encourage others to get in the game, so that somebody does. But I think in that instance, again, it's recognized that everyone has their own priorities and their own budgets and their own competing interests. So,
and just in terms of a budgetary issue, the budgetary aspect, I suppose, again, is another practical one. Now, are the costs borne by the department?
Yeah, I mean, that's certainly in the instances that I know, and it's actually kind of an interesting thing. Recent changes in 2009, the Environmental Enforcement Act directed all fines to go to this environmental damages fund. But it's an interesting thing because while that's good, I think, from the perspective of putting those monies towards restoration projects and that kind of stuff, I've thought about it, agencies, and perhaps this is maybe the risk as well, but if agencies were able to recover some of the money that they spend on enforcement, they might be more inclined to do so. But I think that there's risks on the other side of that as well.
Another practical question, and it relates to recent changes over the last few years to federal environmental legislation. Most of the major pieces of legislation you talked about have been amended in some significant ways, as I'm sure the environmental community has mentioned to you. And not just the ones you mentioned, things like Navigable Waters Protection Act, there's significant changes there. I won't ask you to be too controversial here, but I would like to know whether or not that has a significant effect in terms of the caseload now for environmental prosecutions.
So I guess I'll take an easy answer, and I'll say that a lot of those changes, at least the ones to the Fisheries Act and the Navigable Waters Protection Act, are not yet enforced.
Yeah,
and we don't know when they will be, and so so it's too soon to tell.
Yeah.
I think it's clear. I'm not giving away any secrets. That certainly the government is in a bit of a cost-cutting cycle right now. Departments are looking to save money, and that's been in the news and all that kind of stuff, and so. There are going to be less resources on the ground. And so the question is whether or not the change to the legislation will complement that or make it or not. And I wouldn't be able to say at this early stage.
Okay. I'm going to anticipate a paper that we're going to have tomorrow, which will be delivered by someone not in government. And it goes to this issue of, government is stretched. It can only do so much. Doesn't that logically raise the question of private prosecutions once again? Governments haven't always been inclined to let private prosecutions go forward. Do you think that that's an area that government actually might consider in the future, in a way that it's certainly given a lot of vitality to environmental litigation in the United States? Is there, in your view,
I think, I know that there will be a talk on those tomorrow. There is a resource benefit to private prosecutions. I think persons in the government and also maybe our political masters would suggest that the decision about prosecuting is a multifaceted one. And so it's not always clear to them that more prosecution is in the public interest. And I would leave it probably at that point.
Fair enough. Just one final question on a very narrow point. I was interested to hear your comment about judicial notice. I think it was in the context of 36.3. I was surprised a little bit by that. I wasn't aware of it. Are there examples other than Silt where courts actually take judicial notice of that sort of thing?
So, I won't be able to give you like a lot off my head, but certainly, so Keno Hills, United Keno Hills, the case that's really the foundational case for sentencing environmental harm. The judge there mentions, for instance, that judges can take judicial notice of the importance of environmental harm. Mm-hmm. I think there is a precedent, and I think it's probably a paper to be written unto itself. But there are, I think, substances that, I think, what was it, Bunker C oil in the McMillan Bloedel prosecution out in BC. I don't think the judge spent much time, wasn't too concerned. He was prepared to find that was a deleterious substance. And so the role, so certainly those obvious substances where things get a little tricky, and where we have some interesting case laws around the sort of the naturally occurring substances that might be present in certain concentrations that exceed, some harm threshold, or those ones, the naturally occurring ones. And so in that context, it gets a little, silt at the end of the day is in fact a naturally occurring substance, and in fact it's very common in lots of river systems. Sure. So I don't think that case, that's actually I'm trying to remember, I think I have it's the Jordan case out of BC. It actually hasn't been cited that many times, so I think, I don't know how binding it is, but certainly I think it's not unreasonable. Prosecutors do tend to invoke it in that context. Okay. Yeah. It actually speaks a little bit. I know that in the past, we did have one incident that was reported to us, and I was dealing with it a little bit, and I had just read the case maybe, and so I was having a discussion with the PPSC prosecutor, and she made the point, which I think is similar to what Paul mentioned in terms of strategy. It's well and good to prove academically or in a legal theory sense that the offense has occurred, but if there's no actual harm, it's sometimes hard to get the judge to bite. And so I think that in those instances, prosecutors will generally also look for some kind of harm, even if it's not required necessarily by the offense.
I thought I'd just finally give a federal representative a chance, even though it's not part of your paper, to comment on the intergovernmental aspects that Susan McCrory talked about at some length. I don't know the degree to which you've had involvement in intergovernmental aspects, but I think if you had a comment, it'd be interesting.
Well, I think the comments she made are bang on. We did have one incident where I think, in a sense, it might have been, for all the bad reasons, just schedules. There was a prosecution out of Belleville that actually Alex was also involved in with Mr. Sinclair, who did all kinds of terrible things. And in that instance, actually, there were essentially two parallel proceedings for a lot of it, and that just seemed to be, and in fact, two different judges. And that was unfortunate because there was a lot of issues on that file that were, very common, and some of those decisions are reported and some of them aren't and stuff like that. So sometimes it doesn't work out. I think that the goal is for it to work out, absolutely. But sometimes it might even just be, issues unrelated to either counsel. It might be schedules and limitations, booking certain amount of time, trial time, and all that kind of stuff. Yeah, so that's actually, I'll maybe finish on that point. One of the comments that was made earlier and throughout is this idea of specialized courts. And so that's, I think, I mentioned briefly, I refer to a paper if anyone's interested. It's by the Chief Justice in Australia of a specialized environmental court. They have a land environmental court there, and I think those kinds of issues, so where it's awesome to have the prosecution, federal and provincial, working together. I think if you have a court that's designed specifically for those issues, they might be even, that might be the third player that you could throw in and make those things work.
Of course, we have things like tax court and so forth in Canada. Do you know whether or not that is
No, I don't.
something that's even considered in
I think maybe in the day it was, back in the day. I'm
Yeah.
reviving it now, so.
Yeah, okay. Well, I'll take notice. Okay, thank you very much. Thank you. And we'll take a break now, and we'll resume around 3:15. Thank you.